The end of lawyers. Rethinking the nature of legal services. Richard Susskind. 6. Resolving and avoiding disputes. One morning in early January 2, as I sat at my laptop writing this book, I received an unsolicited phone call from a man employed by a claims company. He wondered if I had recently been involved in any accidents. I paused for a short while before answering, and in that hiatus I thought I could hear him salivating. He was hoping to hear that some calamitous event had recently left me severely disadvantaged. Knowing perfectly well why he was calling, I asked him why he was calling. He explained that his company might be able to secure compensation for me. I explained with no regret that I had suffered no relevant injuries. Yet I was troubled by that call. On the one hand, I do think that many of the new-look claims companies serve a serious social purpose. If a citizen has endured significant loss and may be hesitant about approaching a conventional law firm or embarking upon legal proceedings, then these organizations may well provide a route to recompense that was formerly not available. This rather benign view focuses, of course, on the needs of the consumer rather than the motives of the provider. However, and on the other hand, a more cynical interpretation might suggest that these companies are encouraging people to contrive claims when no real loss or genuine inconvenience has been endured, and it is a short hop from there to a society where legal action is regarded as a source of income rather than a form of restitution. I share the nervousness of many who worry that the work and marketing of claims companies will give rise to a more litigious society in the UK. And this nervousness, I am quick to add, also extends to lawyers who are ambulance chasers, as it does in more subtle ways to contingency fee arrangements, under which lawyers can enjoy a percentage of the damages awarded to their clients, and to the external funding of litigation, whereby third parties can fund legal actions and receive substantial payback in the event of success. I welcome greater access to dispute resolution, but condemn people, lawyers and citizens alike, who play the system. I find it depressing, for example, that otherwise law-abiding citizens stretch the truth to support suspicious whiplash claims when there are car accidents, or exaggerate the losses suffered when formulating their claims for damages or insurance. These are no less dishonest than the often fraudulent claims of those who sue local authorities, maintaining that they have been injured by tripping over uneven slabs on pavements. I salute attempts to streamline and speed up dispute resolution processes, but am concerned that the improved system might make it easier for the dishonest, vexatious, and the avaricious to pursue their own dubious ends. I want citizens and organizations to be able to assert their legal rights, but I will work to resist the emergence of a culture that is compensation-obsessed and excessively adversarial, combative, litigious, and claims-conscious. I know that red-blooded litigators will dismiss the last few paragraphs as armchair idealism. Many court lawyers will say that the name of the dispute game is gladiatorial combat, and any thoughts of greater cooperation amongst warring parties are naive and misplaced. At the risk of getting sued, I generally regard this as rhetorical posturing on the part of senior lawyers that is more often self-serving than client-facing. Of course, in disputes where the very life of an organization may be at stake, a wholly robust stance is likely to be taken and a fight to the bitter end, using the full force of the law and lawyers, may well seem inevitable and even understandable. But we should not claim in the grand landscape of dispute resolution that such conflicts litter the terrain. And we should also be alive to the possibility that head-on conflict, even in the weightiest of disagreements, may not ultimately be in the interests of any parties involved, aside from the lawyers. I accept that human beings and organizations will tend to have disagreements. Even in peaceful communities and in civilized times, we will find overlapping interests, direct rivalry, and fierce competition, all of which can bring parties into some kind of conflict, from mild to extreme. Given that human beings are limited in their generosity, their natural resources, and their willpower, disputes are bound to arise. It would be an exceptional society whose inhabitants were never in dispute, and in turn would have no need for the law. This would require a level of interpersonal accord and coherence that is scarcely imaginable. Aristotle says it all when he notes, when people are friends, they have no need of justice. In contrast, when men are acquaintances, strangers, and competitors, we should surely accept that disagreements are all but inevitable. It does not follow, though, that we should uncritically accept the current mechanisms that our legal systems provide for the handling of disputes. Today's lawyers, courts, systems, and processes, underpinned by our prevailing culture, expectations, and even our art and literature, on stage and in novels, for instance, we generally find a stereotypical portrayal of combative litigators in fierce opposition to one another. In the spirit of this book, I challenge the status quo. As elsewhere in the law, I have no doubt that our current ways of resolving disputes can be decomposed into constituent tasks that could be solved in different and more efficient ways. I see no reason why the pressures that are leading clients to urge their advisors along the path towards commoditization should not also extend to litigators. Equally, I can find no sensible objection to investigating the greater use of information technology, IT, in the dispute resolution process, both to automate and streamline current working practices, and also to introduce radically new and even disruptive technologies. The introduction of new efficiencies and technologies is long overdue. Too often, the expense of litigating in our courts is absurd. Often the cost of litigating exceeds the amount at issue. Much of this expense is down to the intermediaries who sit between those in dispute: solicitors, barristers, technologists, experts, and the court system itself. This traditional legal apparatus and industry that has been built on human conflict is frequently unwieldy and often unfit for purpose. The heavy-handed involvement of lawyers and courts can distort the process of resolving disputes, diverting focus from the parties to their advisors, driving an often unnecessary wedge between the clients themselves, and incurring disproportionate costs. As elsewhere in this book where we find intermediaries, I entertain the possibility of disintermediation, removing the middlemen from the process, and where there are gross inefficiencies, I suggest that fundamental overhaul should be considered. I go further: if we can find ways of avoiding disputes altogether, then we should not shirk from examining these as well. And when we cannot prevent or preempt disputes, we should be looking hard for ways to contain disagreements amicably and to avoid unnecessary escalation. Then we should not shirk from examining these as well. In this chapter. 6 reforms and changes as a springboard for my discussion about the resolution and avoidance of disputes. I begin by considering 3 relatively recent attempts to bring about improvements to our justice system: the reforms of Lord Woolf, the adoption of alternative dispute resolution (ADR), and a government initiative launched at the peak of the dot-com era. Turning first to Lord Woolf, in March 1, Lord Mackay, the then Lord Chancellor, announced there was to be a review of the rules and procedures in the civil courts in England and Wales. He invited Lord Woolf to lead this inquiry. At that time, Lord Woolf was a Lord of Appeal in Ordinary in the House of Lords, a Law Lord. Later, from to he would be Master of the Rolls, and in mid-2 would be appointed the Lord Chief Justice of England and Wales, a position he held until 2. During that decade, he became a towering influence on reforms of the courts and the judiciary, both constitutional reforms and changes to the working practices of judges and the legal profession. I was delighted to be appointed as IT consultant to Lord Woolf in early 1. It seemed to me then that the very appointment of someone who specialized in legal technology was of itself significant. I did not know of any other prior law reform initiative in the UK that had taken it particularly seriously. The aims of Lord Woolf's review were, in summary, to improve access to justice, to reduce the cost of litigation, and to reduce the complexity of the rules and terminology, a tall order. The review itself became known as the Access to Justice Inquiry. In June 1, Lord Woolf produced an interim report. And in July 1, he published his final report, together with a set of draft rules, proposing a unified body of rules to replace the rules of the Supreme Court and County Court rules. Lord Woolf recommended a new landscape for civil litigation. In the new world he advocated, he suggested that civil litigation should be avoided wherever possible, less adversarial and more cooperative, less complex, more certain with shorter timescales, and more affordable, predictable, and proportionate. He recommended that parties should be placed on more equal footing financially, that there should be a clearer division of judicial and administrative responsibilities, that the courts and judges should be more litigant-oriented, that there should be a more effective deployment of judges, and that the civil justice system should be more responsive to litigants' needs. When the Labour Party came to power in England in May 1, after reviewing Lord Woolf's recommendations alongside various proposals for the reform of the legal aid system, they published a white paper in December 1, entitled Modernising Justice. This led in April 1 to the start of the first phase of the implementation of a major suite of civil justice reforms, largely as envisaged by Lord Woolf. There is some dispute amongst litigators and commentators as to the lasting impact of Lord Woolf's reforms. For my part, I believe that his articulation of the shortcomings of the civil justice system was definitive, and that his recommendations themselves have had enormous practical impact, not simply in changing the rules, procedures, and practices, but also in shifting the culture of dispute resolution in England and Wales. The system that has emerged still suffers from many imperfections, but for the purposes of this book, I am drawing attention to the broad thrust, a government-backed set of reforms that have moved some way to reducing the costs, complexity, and inaccessibility of the English justice system. Lord Woolf's proposed reforms in the mid-1990s also dovetailed with the growing interest in and success of ADR. The result today is that far fewer cases are pursued through the courts than in March 1, and many litigators no longer operate as conventional court lawyers. It is worth dwelling on the ADR movement, this phenomenon that predated and then ran in parallel with Lord Woolf's inquiry and the later implementation of his proposals. I first encountered ADR in the early 1990s when I was working at the international law firm Masons, now Pinsent Masons. I was asked to edit an explanatory and promotional booklet on ADR for the UK firm. It had been drafted by Tony Bunch, later to be managing partner of the firm, who had just returned from many years in our Hong Kong office and was re-establishing his practice in London. In Asia, we learned there had been many positive experiences of using methods of resolving disputes that were quite different from conventional litigation. Tony brought news of mediation, conciliation, adjudication, mini-trials by neutrals, and several more techniques that enabled disputes to be resolved away from traditional judges and the shadow of the courts. At the time, Mason's was the leading global practice in construction law, and its particular focus was large-scale litigation. The firm was in the middle of advising on the Channel Tunnel dispute, then one of the largest cases in European legal history, both in terms of the size of the claim and the very large number of documents involved. Admittedly, this case was far from typical. But there always was a wide range of significant construction disputes on the books of the firm, and conventional mainstream litigation was taken, almost without question, as the definitive route to resolving these conflicts. In short, larger-scale litigation was the lifeblood of the firm, and so suggestions of ADR seemed exotic, if not outlandish. 18 years on, in major Masons as in many major law firms, in its various manifestations, has become a mainstream tool. Litigation is no longer seen as the single dominant means of settling differences. Across the English legal system, the most commonly used form of ADR is mediation. Where parties itself, sadly a term that smacks of the courts, do not manage to settle their differences by negotiating on their own, the services of a mediator can be retained as an impartial catalyst who helps to identify an outcome with which the parties are comfortable. The mediator does not judge or determine issues, nor can the mediator impose a decision. Without needing to resort to courts or formal proceedings, the mediator often helps parties to reach a pragmatic and voluntary settlement in a manner that is invariably less public, formal, confrontational, and debilitating than litigation, and in a way that is often more likely than through legal action to preserve good relationships. Nonetheless, it is still strongly argued by many in the litigation fraternity that in disputes where the survival of the parties may be at stake, so-called bet the ranch disputes, all concerned are more likely, or so it is argued, to engage in highly combative gladiatorial combat. Others counter that this excessively confrontational approach is in the interests of neither party, and that a more conciliatory settlement of conflict is more rational for all concerned. Experts in game theory should be let loose here, pondering and weighing the various incentives and motivations for escalating disputes as against handling them in a more measured and mellow manner. In any event, Lord Woolf's reforms and the ADR movement have, in combination, given rise to a shift of emphasis in the much-changed world of dispute resolution, away from court-based litigation as the natural first port of call when a serious dispute arises. Can more fundamental change be envisioned? With one exception, I have found, amongst policymakers and litigators alike, an apparent reluctance to think about more radical transformation of courts and litigation. The exception was Civil Justice, a consultation paper issued by the Lord Chancellor's Department in September 1. This was the result of an exciting initiative led by Jeff Hoon MP, then the Minister of State at the department. Perhaps best known some years later as the Secretary of State for Defense during the invasion of Iraq, Jeff Hoon at that time was preoccupied with the civil justice system and how it might be improved and even overhauled. Hoon led the Civil Justice Initiative with great enthusiasm and considerable integrity. The title of the paper, which may not have withstood the harsh test of time, reflected the excitement in over the dot-com movement. Hoon wondered about the impact of the internet on the legal system and set up what was known as the Civil Justice IT Strategy Development Group, of which I was an active member. In the second chapter of the consultation paper, some fundamental assumptions about the civil justice system were challenged under 16 headings. For example, we questioned whether or not the work of the civil courts needs to be conducted in physical courtrooms with parties appearing in person, whether the resolution of disputes is best conducted on an adversarial basis, whether presentation of legal arguments orally is central to the administration of justice, whether the legal profession is well or best organized as a two-tier profession, and whether the civil justice system concerns the resolution and not the avoidance of disputes. These were issues that I and other members of the group felt had been skirted around in previous reviews of civil justice, including Lord Woolf's. We further felt that the advent of the internet presented an opportunity to rethink civil justice and to take no institutions or practices for granted. Around 60 responses to the consultation paper were received from a wide cross-section of interested parties, including lawyers, consumer groups, court users, and judges, and in June 2, the Lord Chancellor's Department responded by publishing a strategy paper, Civil Justice 2. By this time, Jeff Hoon had left the department. His successor as champion of the initiative was the Parliamentary Secretary David Locke MP, who brought fresh energy and support. Indeed, in my view, that strategy paper represents the most promising and ambitious statement of government reform of the court system, advocating, for example, virtual hearings, electronic case files, and video conferencing. Alas, when David Locke lost his seat in Parliament and was no longer driving the programme ahead, the boldness of the strategy paper was not embraced by his successors, and the government simply did not follow through. In the background, and this is a running theme, HM Treasury was reluctant to make funds available for radical improvements to the court system. In short and tragically, the impetus was lost. A few relatively minor investments were made, but to this day, the fundamental questions we asked remain substantially unanswered, and the proposed reforms remain unimplemented. Nor have practicing lawyers been inclined to challenge the status quo. Indeed, I sometimes hear senior lawyers and judges discussing some of the assumptions identified in civil justice, but in tones of uncritical acclamation rather than reasoned reflection. I hear, for example, that the adversarial system, oral pleading, and the split profession are golden threads or jewels in the crown of our justice system. This may well be right, but rarely is supporting evidence adduced. We cannot assume these claims to be true a priori, as philosophers would say. If we are serious about the future of our court and justice systems, we should not be afraid to ask bold questions and to challenge conventional assumptions. Intellectual honesty and sound policy making demand that there should be no sacred cows. To some extent, then, my purpose here is to reignite some of the debate we started in one, even though I am just scratching the surface of some profound issues. I do not, in fact, address the three issues just mentioned, but I encourage others to do so. However, I do explore two of the major themes of civil justice, the need for congregating in physical courtrooms to settle disputes, Section 6, and for dispute avoidance as well as dispute resolution as a responsibility for the legal profession, Section 6. Further, I call once again throughout the chapter for the more widespread adoption of a range of information technologies that would help to bring our justice system from the 19th into the 21st century. 6. Decomposing dispute resolution. As elsewhere in this book, I start by looking at law firms. The intuition of many battle-hardened litigators in private practice is that the relative uniqueness of the cases they handle means that the heart of their work will be largely untouched by advanced technology and other modern efficiencies. They can see that their deal-making colleagues should be wary of future developments in it and trends such as outsourcing, but many in the world of dispute resolution anticipate no IT-based alternative to their basic conventional craftsmanship. This, I feel, is short-sighted. I take the view that solicitors involved with dispute resolution, especially in litigation and arbitration, should be considering where their work fits along the evolutionary path that I chart out in Section 2, and should be assessing the possibilities of decomposing and multi-sourcing, see Section 2, as carefully as their non-contentious colleagues. Today, many law firms treat the handling of a dispute as a single, monolithic, indivisible job that is given to them to handle in its entirety. However, even at a glance, it can be seen that the dispute resolution work that they undertake can be decomposed into a variety of constituent tasks. For example, one component task is legal research. Much of the analysis and exploration of the law, as it applies to any particular case, is often undertaken by fairly junior lawyers whose output, although well-intentioned, is not always especially expert, and often consumes considerable time because the novices in question are not entirely familiar with the field. In a sense, this was the premise or mischief that led to the establishment of the US-based company, LRN. Dov Seidman, a Harvard Law graduate with a passion for delivering legal services differently, set up LRN to build a network of legal academics, retired judges and practitioners and other specialists who, when appropriately briefed, could produce first-rate legal research in very short order. Seidman argued to General Counsel that in major disputes, in-house legal departments should handle legal research separately, diverting it away from junior lawyers in external law firms towards LRN's dedicated legal research business. In the language of Section 2, this often became a form of subcontracting or local outsourcing. Some major international corporations even came to insist that all legal research, for which their external law firms would charge in excess of a given sum, instead be passed to LRN. Another component task of litigation is document management. In any dispute, there are documents to identify, gather, organize, index, and review. While again, this task is often passed to junior lawyers, there are growing bodies of specialist companies which have teams of paralegals who have greater experience in document management and are supported by more advanced systems and processes. While some paralegals remain within law firms, increasingly their services are being delivered by third parties. In the terminology of Section 2, this might be a species of de-lawyering or, on other occasions, a type of outsourcing. When the documents involved have been originated and are stored electronically, this raises the formidable challenge, discussed in more detail in Section 6, of electronic disclosure. A few firms have built their own internal resource to cope with this challenge, but many more accept that this highly technical job is best left to third-party specialists. Equally, once documents are identified and organized, they may be stored for consultation, manipulation, and search by litigation support systems, see Section 6. And once again, while some firms have their own litigation support capability, external third-party providers are often more experienced and expert. Decomposition of dispute resolution work will also identify a further task, that of project management. In large disputes especially, the organization, progression, and control of all related resources, people, parties, advisors, documents, in accordance with strict timetables, is essentially a project management task, see Section 4. Although, as I say on other occasions in this book, many solicitors in English law firms will say that their central task as litigators is that of project management, I challenge the extent to which many lawyers are genuinely trained and skilled in this complex area. Yet again, this is another task that can be de-lawyered and subcontracted to external specialists. And so, in dispute resolution, we can already see that legal research, document management, electronic disclosure, litigation support, and project management can all be parceled out from law firms that traditionally would have been responsible for all these tasks from start to finish. It might well be asked what is left for law firms to do once these various component tasks have indeed been distributed elsewhere. Certainly, we should expect law firms to formulate and advise upon the strategy and tactics for a dispute, and perhaps to be involved in ongoing negotiations, though this is an area of expertise in which full-time professional negotiators could instead be involved. It is also possible that firms can take on any advocacy, but in England at least, although there are solicitor advocates, this key job still tends to be sourced through expert barristers. Interestingly, barristers withstand decomposition rather well. These skilled, deeply knowledgeable lawyers have not strayed beyond their core competence of delivering legal expertise through opinions and through advocacy in court. There is little there to be sourced in alternative ways. In contrast, the dispute resolution or litigation functions of many law firms are surely threatened by decomposition and multi-sourcing. The underlying imperative here is, as discussed in Section 5, clients' growing need to reduce their expenditure on legal matters. If other methods of sourcing can reduce the cost and indeed increase the quality of some constituent tasks of the dispute resolution process, then, as clients come under increasing financial pressure, they will direct their law firms to decompose and multi-source accordingly. Some major law firms will be able to resist this by setting up their own internal capabilities, for example in electronic disclosure and project management, but whether these will be able to compete with leaner, dedicated, often more business-like third-party contractors remains to be seen. Perhaps the greatest opportunity here for law firms is for them to take on an oversight and project management function over and above their roles as strategists and tacticians. This would involve firms in, Initial analysis of the best ways of multi-sourcing a dispute, allocation and subcontracting of tasks to providers, supervision and quality control of these multi-sourced providers, and branding of the final product. Law firms, in this way, would remain the first and main ongoing point of contact for clients. However, they may face stiff competition here. Others, such as in-house lawyers and management consultants, may also see the attraction of overseeing and managing work in this way. 6. From litigation support to electronic disclosure, one of my bolder predictions in the future of law ran as follows. The stage is set for major change in the world of litigation. Even by large-scale or complex litigation without it will be virtually unimaginable. One at the time, I had in mind the impending impact of litigation support systems. Whatever the worth of my original prediction, I believe in that heavy-duty litigation without technology is now even harder to conceive, largely because of a phenomenon closely related to litigation support, that of electronic disclosure. A little history is in order. One of the first applications of it in the metaphorical front office of lawyers, as opposed to back-office uses such as word processing and accounting, was litigation support. First introduced in the US in the mid-1960s and embraced more extensively there since then, litigation support systems convinced many practitioners in England and Wales in the early 1990s that it could directly affect legal practice and the actual delivery of legal service. The attraction of this technology was simple. In large disputes especially, lawyers had to organize and pore through piles of documents. Surely it could help. Instead of having teams of paralegals and junior lawyers thumbing and fumbling through mountains of files, litigation support technologies promised to streamline the manual processes. Once documents were loaded onto a computer, searching, retrieval, cross-referencing, and annotating could all be supported through it. Lawyers could locate relevant papers more quickly than using handcrafted methods. 3 techniques have dominated litigation support over the past 20 years. One approach has been to compile electronic indexes of documents relating to cases. Each document in a case can be represented in a database as a collection of objective features, for example, the date of document, author, recipient, as well as subjective features, requiring lawyers' classifications, such as whether a document is privileged or prejudicial to the client's case or raises a particular point of law. Once set up, such a system can sort all documents, for example in date order or by author's name. A second and complementary approach to litigation support has used document image processing technology. This relies on a scanning process which can be likened to taking and storing photographs of individual documents, so that this technology can cope well with materials that are neither printed nor typed, such as drawings or documents with handwriting, signatures, marginal annotations, date stamps, and so forth. Users of systems that hold images cannot search for individual words within the imaged documents because the text is not held in machine-readable form. The third technique has been to build a retrieval system that holds not an index, but the full text of a collection of papers. This has enabled lawyers to search quickly and easily within the entire text of documents for the occurrence of single words, for example names of individuals, companies, places, or terms such as warranty or delay, or for words in combination, for instance the name of a company within a specified number of words, or the name of an individual or a phrase such as defective software. Advanced users have found that the greatest benefits of litigation support come with a judicious combination of these 3 techniques. There is some considerable expertise needed in selecting, for any case at hand, which one or more of the 3 appropriate technologies should be deployed. This is a decision over which lawyers often agonize. Some firms have gone further by hyperlinking the documents held in litigation support systems with the opinions and advice being generated by the lawyers, thereby creating a work product management system of sorts. It should be recognized that none of these litigation support technologies detracts from the need to read documents in the first place. In the absence of what are known as natural language processing technologies, it is hard to see how computers can undertake an initial review of documents. This means that any competent lawyer or paralegal has to look through case documents once, for it is only during this first pass that the relevance or otherwise of the documents can be assessed. One aim of litigation support, it might therefore be said, is to ensure that full sets of documents should not need to be read more than once. What other advantages does litigation support bring? Some lawyers hanker after strategic benefits. In complex cases such as large-scale commercial construction or computer disputes, it is often said that the party who has mastery of the documents will enjoy a clear advantage over others, and so well-conceived systems can provide this edge. More prosaically, the overriding aim for other lawyers who use these systems is to handle the documentation more efficiently and so control the costs of disputes. Whether litigation support, in fact, reduces the cost of litigation is not clear, however. One view I hear from seasoned users is that these systems enable lawyers to do far more for their clients, more thorough and comprehensive work in the available time, but for the same, but not lower fees. I should also mention reluctant users. Some lawyers of Luddite inclination only use litigation support defensively. They would prefer not to be users at all, but are sometimes motivated into deploying the technology by a fear of being left behind, when, for example, opposing parties have indicated they are using IT, or it is suspected that they are. How widely have litigation support systems been adopted? Was I hopelessly misguided in predicting that by large-scale or complex litigation without it would be virtually unimaginable? On balance, I was misguided, but not perhaps hopelessly so. In the US, the take-up over the last decade has been far greater than in the UK. There is, and has been since also, a strong expectation amongst American firms and clients that serious disputes involving large numbers of documents are best handled with the support of technology. This is not to say that there are no advanced users and sophisticated suppliers in England. On the contrary, some are as leading edge as can be found anywhere. However, the technology is far from pervasive. In my experience, mainly from my consulting work, a comparatively small number of English practices use the technologies as a matter of course, and only a similar proportion of clients insist on their usage. I find this remarkable. Certainly, if I had to instruct lawyers on a document-intensive, high-value dispute, I would not countenance the use of manual methods alone. A well-designed litigation database is immeasurably more useful and efficient than, say, card files and yellow sticky notes. Why then has the uptake of litigation support been relatively modest, in England at least? Once again, echoing my observation in Section 5. About incentives, I suspect that conservative law firms would prefer to stay in their comfort zones, hang on to the old ways of working, and perpetuate a system, hourly billing, that rewards cumbersome manual methods rather than streamlined electronic techniques of document management. In short, if the main impetus for litigation support is to come from law firms alone, progress in many corners of the profession is likely to be slow. Solicitors and barristers need to be driven harder. This is a sad indictment of clients. I simply cannot understand why commercially savvy clients, whether in-house lawyers or laypeople, do not demand that large piles of documents are organized electronically. Why pay for systemic inefficiency? Clients, in-house lawyers and top managers should be more knowledgeable and demanding. Judges should also shoulder some of the responsibility and be more insistent. In their expanding role as case managers and applying their conventional powers to award costs or not, depending, for example, on whether a party's expenses have been reasonable, judges could help to modernize the practices of law firms. If disputes can be resolved more quickly and at lower cost by using it, then they surely should be, whether or not this is in the financial interests of law firms. In fairness, there are two credible counterclaims to this line of argument. The first is that litigation support is wonderful or at least beneficial, but only suitable for the largest of disputes, those that involve vast quantities of documents. Where the document load is smaller, it can be suggested there is no point in using litigation support. A sledgehammer to miss a nut, I have heard it called. Although superficially plausible, this trajectory of thinking is wrong-headed. Accomplished users, in stark contrast to non-users who speculate, invariably report that litigation systems are invaluable whatever the size of case. In all disputes, there are documents to administer, and it is invariably more efficient at this than manual systems. The argument from Zeiss is not supported by experience. A second defense focuses on cost. The common concern here is that litigation support systems are prohibitively expensive, a position caricatured by the no doubt apocryphal tale of the international corporation whose in-house lawyers, in defending a massive claim, exceeded the unlimited budget that had been allocated to them for litigation support. Understandably, the prospect of large upfront expenditure on litigation databases horrifies many clients. More than this, early investment in it is also inconsistent with the post-Wolf landscape for dispute management, which urges early resolution and not strategic preparation for a long-term wrangle. Be in no doubt, the euphoria of a negotiated settlement can be diluted dramatically by the appearance of a titanic bill for litigation support. A sophisticated response to this argument from cost holds that the speedy setup of powerful litigation systems can of itself bring about earlier and more favorable settlement. This was always the view of one of the doyens of litigation support in the US, Deanne Seamer. One of her tactics as a trial attorney was to load documents into a database at a very early stage in the dispute, run some standard queries, she maintained a library of these, and freak the other side by showing an early and apparently uncanny mastery of the evidence. The argument from cost is also weakened by changing patterns in the use of it. Remember that in the early days of litigation support, most of the documents that were being loaded into these systems had been originated on manual or electronic typewriters. The master file on any given project, all the relevant documentation, was invariably a set of papers, often held in a collection of lever arch files. To transfer the master file into a litigation support system of the imaged or full text variety involved scanning these papers or converting them, using optical or intelligent character recognition, into the system. This scanning and converting was costly, hence the upfront expense. Fast forward a decade or so and documents were increasingly being created by word processing, and so were in some kind of machine-readable form from the outset. It was for this reason that I suggested in The Future of Law that document management systems were nascent litigation support systems. At the flip of a switch, I said in my book and to clients of law firms, if you set up your electronic filing systems, broadly document management systems, in a sensible way, then they could easily be repurposed as litigation systems in the unfortunate event that a dispute arises. The cost implication was clear. If you organized your systems with half an eye to managing the risks of disputes, then the cost of setting up a litigation support system would be modest. It would simply be a document management system used in a different way. It might be thought today, given the fact that documents, now word-processed materials and emails, are almost exclusively originated in electronic form, that all organizations, as a matter of course, develop document management systems that can double as litigation systems. Instead, this electronic origination has brought a whole new challenge, that of electronic disclosure or e-disclosure, also known as e-discovery. I anticipated this phenomenon in the late 1990s while advising senior English judges on likely future trends. But in the event, the scale and criticality of the issue has extended well beyond my expectations. Disclosure involves parties to a dispute letting one another know about the existence of relevant documents. It helps them to prepare for trial by indicating what evidence the other side has. Historically, disclosed documents were handwritten or typed, and parties then exchanged bundles of paper. Today, the overwhelming majority of documents are created electronically, using word processing or email, generated in far greater quantity than in the past. Many are never printed, most are backed up while new versions are created, some are deleted but can be recovered, while information about documents metadata is now also captured, for example, dates of creation and amendment. In short, disclosure is no longer about piles of paper. Electronic disclosure involves a potentially boundless, high-tech digital trawl through innumerable systems and files for explicit and hidden information and meta-information. For banks especially, the requirement to disclose extends beyond conventional litigation to regulatory investigations, where similar demands to make documents available can be made. It is more than a challenge. It is a logistical, technical, and legal minefield. Logistically, electronic disclosure is particularly daunting for most large organizations, whose electronic filing systems tend to be, frankly, vast and chaotic. One way of looking at the problem is to think again of master files. While they used to be paper-based, they often no longer exist. The documents relating to a given project, for example, might include emails, spreadsheets, databases, presentations, graphics, and video files, as well as conventional word-processed documents. Some are printed out and put on file, but there is seldom a systematic attempt to bring them all together in one single location, whether paper-based or electronic. The master file has largely disappeared. The problem here is that when a dispute arises, organizations and their advisors need to isolate all relevant documents. But if they are not collocated in well-organized files, this task becomes a search for a digital needle in an electronic haystack. I have now heard about half a dozen stories of large financial institutions that have settled disputes prematurely and expensively in anticipation of not being able to cope with the demands of e-disclosure. In the language of Section 3, their filing systems could not yield all but only the documents they needed. When I speak about it to general counsel, especially of global banks with substantial business in the US, I am increasingly finding that electronic disclosure is the only show in town. Anxiety levels are high because they know that their systems for managing documents and emails are crude, and that the isolation of a complete body of relevant materials is a near impossible task. Even when organizations do have document management systems in place, it is still no trivial task to extract and organize all but only the materials that are relevant for disclosure for the purposes of disclosure. To be sure, this is less of a job than scanning and converting from paper into electronic form, as in days gone by, but unless the document management systems were designed with a view to electronic disclosure, now a vital sign of litigation readiness, the work involved is still daunting. Fears about not being able to isolate and disclose emails were greatly fueled by a case in the US. In May 2, when the financial institution, Morgan Stanley, was ordered to pay us $8 million in punitive damages because of its inability to disclose relevant email documentation. In March 2, this decision was thrown out on appeal, although the panel did not rule directly on the e-discovery issue. For the technologist, electronic disclosure constitutes a veritable e-fest. E-disclosure technologists draw on a variety of tools and techniques, including intelligent searching, data mining, and document management systems. Specialist e-disclosure software is also available, with powerful features including deduplication, deduping, which is especially helpful in trimming down messages that appear numerous times in email chains. When a dispute arises, an organization's preparedness now depends, in part, on its ability to extract data rapidly from its document management systems for disclosure purposes. There are analogies here with the work of auditors in the 1980s. They had to become adept at extracting information from clients' increasingly computerized accounting systems, and so the discipline of computer audit emerged. Perhaps a similar speciality will materialize in law. E-disclosure may also lead to greater use of online case rooms, which are dedicated, secure websites to which all materials are sent and from which they can be retrieved in manageable quantities. The alternative, the exchange of vast bodies of electronic documents by email, could bring most firms' networks to their knees. And the volumes are undoubtedly mind-boggling. I recall that about 10 years ago, I was asked to advise on a dispute that involved approximately 1 million documents. The client wanted to know how on earth they might manage such a quantity of documents. At the time, I wondered with colleagues whether the case might in fact be impossible to take to trial, precisely because of the vast quantities of materials involved. In the end, they muddled through, but today such volumes look modest. On one backup tape about the size of a paperback book, it is now possible to store over 1 million pages, and many large organizations have cupboards full of these. From a legal point of view, uncertainties abound. How much electronic material must be disclosed? Should this extend to metadata information about documents such as dates of amendment? Who should pay for the process of recovering data from archives and backups? Above all, how can the cost of e-disclosure be rendered proportionate to the value of a claim? So far, the English legal profession's response to these and related questions has been measured. In October 2, the first sustained piece of analysis appeared in draft. It came from the Commercial Litigators Forum, an influential group of litigators. Their report on e-disclosure emphasized the scale of the problem and showed that England's civil procedure rules offered insufficient guidance to those who were already beginning to struggle with the proliferation of electronic documents. In October of the following year, 2004, another influential report emerged, this time from a working party of the Commercial Court Users Committee chaired by a High Court judge, Mr. Justice Creswell. That document concluded rather optimistically that current English law was sufficiently flexible to cope with the demands of e-disclosure, largely because of the reasonableness and proportionality tests governing the search for documents under existing civil procedure rules. Nonetheless, it recommended various modest amendments to these rules and to the Commercial Court Guide. In parallel and more pragmatically, the Litigation Support Technology Group, LISD, a group of experienced litigation technologists, has produced succeeding drafts of a practice direction for the use of it in civil proceedings, which directly address some of the challenges of e-disclosure. What we have not yet seen in England, however, is a major case before the courts in which the nature, scope, and impact of electronic disclosure have been the subject of dispute between parties. When this happens, and only then, I suspect, will we know the extent to which the English legal system is actually equipped to handle the logistical and technical challenges. I am particularly keen to observe how the principle of proportionality is invoked, so that, on individual cases, the costs of e-disclosure are commensurate with the value of the disputes. I am less sanguine than many litigators and commentators about the ease with which e-disclosure can be accommodated without upheaval into large-scale litigation in England. Further, while the various published reports in England are invaluable, they leave a nagging doubt. They tend to place undue emphasis on where information is physically stored, on what electronic medium it is stored, in what format it is stored, and for what purpose it is stored. The result is that whether or not a document might in law be disclosable could turn in the future on some rather arbitrary criteria, for example where a document is stored and in what format, rather than on sound principles of reasonableness or relevance. In any event, clients need help here, not just conventional advice when a dispute arises, but legal risk management service in readiness for litigation, so that when trouble looms, the state of their document retention and filing systems enhances rather than hinders their negotiating position. In turn, I anticipate that litigators will be able to differentiate themselves in this area, those familiar with the pitfalls, able to offer early guidance, and equipped with powerful technology, both for isolating data and for searching, will be superior in capability to those who are not yet ready for the avalanche. We should learn here from other jurisdictions, and particularly from the US, where e-disclosure has been the focal point of numerous cases, most notably in the landmark series of decisions by Judge Shira Shaindlin in the Zubulake cases. There is much that English lawyers can learn from these judgments, and from other sources too, such as the work of the Sedona Conference, whose Sedona principles have been influential in US juristic thinking. Looking forward, I anticipate that e-disclosure will cast a shadow across much civil litigation and regulatory investigation work in the UK. This is why I now say with even greater conviction that within a very small number of years, any form of litigation without it will be scarcely conceivable. At the same time, and looping back to the earlier discussion about litigation support, the challenge for conventional litigation support systems is far from over. When I wrote about these technologies just over a decade ago, we were grappling with methods for storing and searching through text. Since then, with the increasing capture of voice recordings, for example, many financial institutions record dealers' telephone conversations, and the pervasive introduction of CCTV technology, the much more formidable challenge that emerges is that of using search technology to operate across voice and multimedia files as well. We have much to learn here, as we have done in litigation support since the 1970s, from the intelligence services, who have been laboring for years now to perfect systems that can search across sound and video files for important data. Case management and electronic filing. It is time now to look at our courts. I have advised on the computerization of the courts in England in various capacities over the past 15 years, and since one as IT advisor to the Lord Chief Justice. Looking back, it is hard not be disappointed at the progress that has been made. The reality in England and Wales at least, is that many of our courts remain, in administrative and organizational terms, shamefully antiquated and in many areas are in a parlous state. The running of a large system of courts is a massive, document-intensive, information-intensive, and labor-intensive operation. Most of the administrative and management systems that are in use today were developed at a time when the throughput and workload of the courts and lawyers were much lower than they are today. Many of the systems are crude, paper-based, oriented more towards the process of administration than to the community of court users, and increasingly are unable to cope with growing demands placed upon them. Often, this brings unjustifiably high running costs, inefficiencies, errors, delay, poor reputation, and dissatisfaction. Although few lawyers, judges, and officials would put it in these terms, the court system can be regarded in large part as a huge information system, an entity that receives, processes, stores, creates, monitors, and disseminates large quantities of documents and information. The current setup employs large numbers of clerical staff who maintain and run a very large document management capability, which is partly computerized but is very much paper-based too. Experience from other industries and other jurisdictions strongly suggests that the systematic and widespread introduction of better systems would bring great efficiencies and major cost savings. Anyone who doubts the scope for an organizational step change should pay a visit to the back offices of the Royal Courts of Justice in London and marvel at the piles of papers, files, and ledgers. Well-implemented information technologies displacing papers with systems would blow away the dust and give rise to more productive, responsive, and effective courts with swifter and cheaper disposal of individual cases. Improved methods of filing, diarying, communicating, document production, and the management of cases would bring reduction of delays. There is a vital message here, however, for those who hold the public purse strings. The productivity gains would not necessarily lead to cost savings to the state. Instead, for the same expenditure, the system could process a larger number of cases more quickly. This, of course, rather diminishes the dreaded business case that so many policymakers demand, because, in civil justice at least, investments that save expenditure are generally preferred to those that enhance public service. This is not mere cynicism, it captures the reality of post-Woolf investment in it. In the 2 or 3 years following Lord Woolf's recommendations in his Access to Justice Inquiry C Section 6, there was little enthusiasm from either politicians or senior officials for the technology that he was advocating. However, towards the end of the 1990s, a new wave of ministers and top civil servants at the then Lord Chancellor's Department embraced the idea of an IT-fueled court system with some enthusiasm. Sadly, their proposals for the investment of £2 million in the civil justice system were not accepted by HM Treasury. As I was told, the business case was not compelling. I wondered then about another scenario, closing our courts altogether. Think of the public money that would be saved. Now, that would be compelling. We need a much richer model of business thinking in relation to the courts. Obsessing about reducing short-term costs and failing to account for increases in accessibility combine into a dangerous cocktail that threatens the very future of our justice system. In the event, a modest fraction of the requisite funds was eventually made available to civil justice. In practice, this allowed the government to put in place a robust technological infrastructure for the court system. This was undertaken in the hope that there might be later investment in systems that could build on this infrastructure. However, very little such funding was ever made available, and so we had put in place, crudely, a setup akin to a sophisticated road system, but without any cars. In summary, since the early 1990s, when I began to advise on the computerization of the courts, the Tory and Labour governments have lamentably underinvested in our courts, and the result is an embarrassingly old-fashioned system. I visit and am in contact with courts around the world. Sadly, many seem to be higher tech than ours. Judges and court users in England have to endure interaction with a public body, many of whose systems and processes have not changed substantially for decades. I join many lawyers and commentators who advocate reform to formal litigation and the court system in suggesting that one key to a better future would be the introduction of case management technology. In the first instance, of course, case management systems can be deployed well before a case reaches the courts. Within the litigation practice of a law firm, for example, case management systems operate in at least two quite different ways. On the one hand, especially in relation to large, complex and high-value cases, one category of these systems are in effect no more than project management systems, as discussed in some detail in Section 4. On the other hand, and more commonly, a different kind of case management system within legal practice supports the organization and flow of high-volume, relatively low-value disputes. The incentive here is simple and maps neatly onto the second and third stages of the evolution of legal service, as I explain these in Section 2. If law firms seek to deal with routine and repetitive cases, for example debt collection and low-value personal injury claims, in a bespoke and handcrafted manner, then it is unlikely that they can do so to a high standard and at the same time turn a reasonable profit. To inject greater efficiency, firms seek to standardize and systematize much of the process of handling and progressing these common claims. Similarly, lawyers who undertake work that is funded by legal aid also find that the limited fees available mean that they need to set up case management systems to secure appropriate efficiencies and so make the service viable. However, there is no reason why these case management techniques should not be deployed more widely. Whenever there are high volumes, even if the cases are high value, there is considerable scope for standardization, document automation, and the workflow benefits that case management technology can bring. We can learn much about case management from a system and website of BERR, the Department for Business Enterprise and Regulatory Reform, that streamlines the process of claiming compensation. The Coal Health Claims Unit of BERR has been running 2 personal injury compensation schemes, paying out at one stage around £1 million each day in respect of respiratory and vibration-related illnesses. In 2 over 3, claimants had registered for the schemes, and a further 1 new claims were being lodged weekly in expectation of a final government payout in excess of £6 billion. This has been the biggest personal injury scheme in British legal history and is well suited to systematization. Note that I am leaving to one side some other controversies that have arisen in relation to these schemes, for example the fees earned by some law firms. While their early website originally offered no more than online form filling, later versions provided a start-to-finish e-claims process. Using the online service, solicitors have been able to register new claims, complete and submit claims forms, monitor the progress of individual claims, update personal details, agree employment histories, and manage their entire caseloads. This service shows the power of case management for solicitors and the potential of such technology for managing cases with the court system. Unfortunately, discussions of case management in relation to the courts are often fettered by terminological confusions because the term is used in many different ways. At a high level, I like to distinguish between case flow management systems and case load management systems. The former help progress individual cases through the courts, while the latter assist with the management of the resources needed for given groups of cases. At a lower level, as listed in Figure 6, I identify at least 7 categories of case management system for the courts. This does not make easy reading, but I can find no more elegant way to analyze the possibilities. The first type are management information systems, which help politicians, officials, judges, and others to monitor the throughput, costs, and performance of courts. Then second are case administration systems. These support and automate the formidable back office, administrative, and clerical work of running courts. Third are judicial case management systems. These are intended for direct use by judges to support their work in managing the flow of particular cases for which they have responsibility. The fourth are judicial case management support systems, being the systems used by court staff who assist judges who are involved with case management. The fifth category is non-judicial case management systems, those that help court staff to progress those many cases which are not disposed of judicially. Penultimately, there are case tracking systems that allow court users and other participants who are outside the court system to monitor progress on cases in which they have an interest. Finally, there are document management systems, which, so the thinking runs, store and organize all records and documents relating to cases as electronic case files. These files should be able effectively to flow quickly and cheaply through the court system and be available under strict access controls in electronic form to authorized users as an accurate, complete, and up-to-date record. Each of the 7 categories might be better regarded as subsystem of the next generation of court systems, but they are of historical significance too. Fundamental to the Wolf reforms, for example, were 2 quite different categories of case management system. For example, for the fast track, very broadly, for claims of up to £1 in value other than small claims, Lord Wolf argued that it was vital that the court service had efficient, reliable and effective ways of monitoring and administering all those cases that were following fixed timetables. In terms of the classification above, this required first-rate case administration systems. Such systems continue to be evolved in England at a snail's pace. In addition, it was central to Lord Woolf's new landscape that judges became more proactive in the management and progression of cases on the multi-track. Also, broadly, cases then worth more than £1. In this respect, looking to the medium to long term, Lord Woolf envisaged a range of technologies for direct use by judges in support of their new case management responsibilities, largely on the multi-track. In the language used above, what were needed here were judicial case management systems. This was a rather radical new departure, and he recommended 4 categories of case management system: case tracking systems, producing daily reminders, progress reports, lists of outstanding tasks, and notices of who has responsibilities for further actions, thus supporting judges in supervising, monitoring, and controlling their cases from start to finish. Case planning systems, simple PC-based project management software to enable judges to generate their own plans and charts for cases, depicting timescales, key events and activities, telephone and video conferencing as important tools for judges in maintaining the progress of cases and keeping in direct contact with parties where formal meetings would be impractical. And document retrieval systems to allow judges to gain access to documents relating to the individual cases on which they are working, including full case histories, pleadings, affidavits, orders, and document bundles, for example, and to be able to retrieve these either as images or as searchable text from some central location. In the event, other than a very modest deployment of telephone and video conferencing, none of the 4 has been delivered in earnest. If we are ever disappointed that judges have not fully embraced their new case management responsibilities, perhaps we should not be surprised. They have not been given the tools for the job. Fig. 6 categories of case management system. Lord Woolf's recommendations on judicial case management technology did, however, raise a clutch of further issues. For example, it must always be borne in mind that the different kinds of case management systems are interrelated, such that judicial case management systems are not entirely separate systems. A key objective for the future is to move towards unified court systems that support all 7 case management applications noted above. Case management systems for judges will not therefore be separate and distinct applications. Instead, they will draw on much of the same information that is needed for judicial case management support systems and for non-judicial case management systems. It is perhaps best to anticipate court systems of the future as single systems, serving a range of different users, and judges will be one category of user with their own specific requirements. A version of this vision is sometimes referred to as the electronic case file. For each case running through the courts, there should be a single electronic repository containing both information about the case and documents relating to the case, from skeleton arguments through formal source materials to evidential documents. This broad thinking in terms of electronic case files, although not using this terminology, is behind the design of the systems for the new Supreme Court of the UK, which is scheduled to open in 2. Refreshingly, this is one of the most promising court-related projects with which I have been involved. It is relatively self-contained, the number of users will be small, the quantity of data and throughput of cases will be manageable, and there seem, in early 2008, to be funds sufficient to deliver the systems as specified. I am hoping the Supreme Court systems will be a flagship project for case management in all senses. Interestingly, during the course of the Supreme Court project, the need for sound case management systems of the administrative and document management flavor has come from another direction, the call for electronic filing. Known in the trade as e-filing, this involves, in rough terms, the submission of documents to court in electronic form. For several years now, a number of progressive judges and law firms have been calling for greater use of e-filing in England. In some jurisdictions, for example Singapore, it is becoming commonplace. At least one major supplier is now offering an e-filing service that can be implemented at no cost to the state and only modest cost to the parties. Accordingly, the Ministry of Justice is taking this whole area very seriously. In so doing, it has opened something of a Pandora's box, because the officials progressing the initiative quickly and rightly recognized that e-filing cannot be introduced in isolation from a group of related technologies. At first sight, e-filing appears to entail little more than introducing a system that enables lawyers, parties, and others to send documents securely, reliably, and electronically into the courts. Quite aside from this being mightily less trivial than might be thought, putting in place a robust system to support all the civil courts in the land is not a small undertaking. The success of e-filing also depends on whether there are systems in place to organize the documents upon arrival. For e-filing to work, the courts into which the electronic submissions are being made must have case administration systems and document management systems into which the submitted materials are lodged in an orderly and systematic way. Otherwise, it would be chaotic, with clerks and administrative staff manually filing the innumerable electronic submissions. I liken this to aiming a fire hose into a garden bucket. More than this, though, if the documents so sent are to be useful to judges and officials, then they need to be accessible to them, in the form, in my terms, of judicial case management systems, judicial case management support systems, and non-judicial case management systems. In other words, for e-filing to have any chance of functioning reliably and smoothly, the submissions must slot neatly into electronic case files, to which judges and officials will then have easy access from their desktops. This is not straightforward, but it seems to have become the aim of the now very ambitious Electronic Filing and Document Management (EFDM) project at the Ministry of Justice. From an early aspiration of some forward-lookers to be able to email documents directly into the courts, we have swung round full circle to trying to develop most of the systems that Lord Woolf recommended, but which were not implemented because they did not make the cut at HM Treasury. While I will continue to support the EFDM project, I am realistic about the prospects of it being delivered on time. It is a reasonable prediction that e-filing will be used in some courts over the next few years. Officials are expecting a start date for a national solution, as I understand it. I would hazard an optimistic guess of as the date by which full rollout across the system might therefore have taken place. Even this would require a good following wind, as they say in golfing circles, as well as some heavy-duty investment. However, if EFDM goes the way of most public sector projects, we can expect the rollout date to look naive. Given, in any event that is some time away, I have urged the government to consider interim deliverables, perhaps operational pilot systems that might be introduced into a limited number of courts. I always worry about what are known as Big Bang projects, when the entire solution is introduced in one step and prior to this, there are no benefits to be seen. In the meantime, that is to say before 2013, I think there is an alternative course. I have been encouraged here by the work of a group of specialist solicitors who have developed a system that could turn out to be useful for judges. The lawyers are from the Technology and Construction Solicitors Association TCSA, and their latest in a series of innovations is an online case file facility. This provides participants in a dispute with a dedicated, secure website that can hold a range of relevant documents. Surely judges could also use such a service. Indeed, TCSA work points to a practical and affordable way in which a basic type of electronic case file could be made available to the judiciary much earlier than expected. The TCSA system is similar in concept to the internet-based, online case rooms that many law firms now provide to their clients. The document sets available on these sites vary but often include letters of advice and reports prepared by firms, correspondence between parties, expert witness reports, skeleton arguments, databases of evidential materials, case plans and progress reports, financial summaries of fees charged, links to source materials, and collaborative workspaces where firms and clients can work together. If judges cannot, in the medium term at least, be given their own electronic filing system by the government, why not therefore make online case rooms available to them too? They could be given access to law firm sites, although it may be more appropriate if instead they used more neutral online case rooms provided and hosted by communities of court users, such as TCSA. These could become the definitive standardized repositories for given cases, to which, for example, lawyers would send statements of case, defenses, and other submissions, while judges could similarly post directions, case plans, and decisions. These would not, of course, be sites containing advice from lawyer to client, but would be online stores of the documentation that is generally shared amongst parties to a dispute, including the judge. Such a service would not be part of or automatically linked to any court systems. If court documents were made available in these online case rooms, they would need to be transferred there by a process not unlike sending an email. Nor would these sites be integrated with court diaries or listing systems. Instead, they would be standalone online collections of papers. I would not advocate this approach if substantial funds were clearly available and no one was worried about delay. In its favor is that it would offer a workable solution now for the judges and the courts, and would also be a major step forward towards full-scale electronic case files. Whatever solution is preferred, one issue that remains unresolved in relation to e-filing in the English courts or lodging documents in case rooms is the format in which electronic documents should be submitted. There are strong arguments and emerging technologies in support of the view that electronic documents should be organized not as separate items, but as an interlinked body of documents, so that when judges come to browse, it will be akin to roaming around the web rather than opening a series of distinct Word documents. Take a sidestep for a moment from the intricacies of e-filing to the visionary words of MIT professor Marvin Minsky, who once said, "I understand, that people of the future will be amazed that there used to be libraries with books that did not talk to one another, or words to that effect." A pioneer of artificial intelligence, Minsky was anticipating no fewer than two developments: that texts of the future would be directly linked to one another, and that they would automatically update and revise one another. We might need to wait a while for the second possibility, but lawyers are already comfortable with the first, with navigating through hyperlinked materials. They do so when surfing the web, browsing their intranets, and when using online services that allow users to jump easily from, say, a case report to a section of a statute. However, lawyers have been notably less enthusiastic in providing their own work in linked form. Today, when a lawyer submits bundles of documents to court, even if they are delivered in electronic form, they rarely have a rich body of internal links. This is a missed opportunity because judges would often find it helpful to navigate around an electronic web-like set of documents. and lawyers unfamiliar with the process of creating an interlinked suite of documents should be reassured that tools are readily available to help with this job. All of this is not simply the indulgence of futurists. In Lord Savile's Bloody Sunday inquiry, see Section 6, the use of electronic filing was standard practice. Any documents submitted to his inquiry had to be sent in electronic form, but Lord Savile himself went further and strongly encouraged lawyers not just to submit documents as discrete files. He indeed argued that they should be hyperlinked, joined together so that what came to his inquiry office and swiftly thereafter into his machine was, effectively, an information system, allowing him to roam amongst arguments, transcripts, formal sources, and evidential material. On this model, the burden on the lawyers is not only to prepare and transmit material electronically, but also to insert hypertext links so that the submissions coalesce into a workable information system. Here we see yet another glimpse of the future of law. In the light of the historic lack of funding, am I entirely off-piste in giving contemplation time to all these developments in case management, electronic case files, and e-filing? I often sense when discussing such systems that they are regarded by the mainstream as interesting optional extras akin to sunroofs, metallic paints, and alloy wheels on cars. I strongly contest this. Case management systems, all 7 in combination, should constitute the engine of tomorrow's court system. My hope is that, within a decade and possibly much less, they will indeed come to be widely regarded as central to any modern court system in a civilized 21st century society. 6. Courtroom technology and judges. Many courtrooms of today are equipped no differently from those of the mid-20th century, when modern computers were invented and first used. The actual dispensing of justice, it might be inferred, is a manual handcrafted art upon which it can have little impact. This would be too sweeping an inference. In the spirit of this book, much of what goes on in the courtroom can be handled differently and supported by technology. It is true, I am sorry to say, that the systemic underinvestment in the modernization of the English courts extends from the back offices of the courts into the courtrooms themselves. Nonetheless, there have been numerous instances of advanced technology use in English hearing rooms, and over the past decade, the English judiciary has come to embrace it with some enthusiasm. These uses of technology offer a clear picture of what is possible today, and with sufficient political will, could be implemented within a modest number of years. The story of courtroom technology in England is that of a patchwork quilt. There is no elegant way of discussing the various techniques, nor any possibility of synthesizing them together in practice into a single system. If what follows is rather piecemeal, it reflects the object of study. I start in the early 1990s with a technology known as computer-assisted transcription, CAT. Through CAT, the words spoken in the courtroom as captured by the keystrokes of stenographers are converted into text that appears almost instantaneously on the judge's monitor. There is also a facility to annotate text as it appears. Under the auspices of the Society for Computers and Law, a short research project was commissioned in one that sought to explore the impact of this technology. The study suggested that the use of this technology could reduce the length of hearings, a finding supported by later projects and by the widespread anecdotal evidence of judges who used these systems. Most judges still say that using CAT in their courts cuts time taken by around 1/3. CAT is an interesting case study, although I have not heard anyone challenge the proposition that this technology saves time and money, even after deducting the cost of the CAT service. Its widespread adoption has not been funded by the government. Its usage today, more than 15 years on, is largely confined to large disputes, litigation and arbitration, when the parties themselves agree to use and fund the technology. In the future, perhaps in another 15 years, with the advent, if you will forgive the jargon, of speak-independent, continuous speech, multiple-speaker, large vocabulary, voice recognition systems, today's techniques for recording and transcribing, including shorthand writing, tape recording, and even CAT, may no longer be needed. Thus, proceedings in court may instantaneously and in real time be captured in electronic form, thereby revolutionizing court reporting. So too with meetings and, for example, the taking of witness statements. Voice recognition technology will, in due course, immediately deliver polished transcripts in printed or electronic form. Until then, though, we are left with traditional court reporting and occasional uses of CAT. Two other courtroom technologies that date to a similar period in the history of the English courts are document display systems and electronic presentation of evidence, EPE. The former ensure that everyone in the courtroom is literally on the same page, rather than making a reference to a particular file or folder, then perhaps a tab and thereafter a page number, and waiting for all parties and judges to locate the page manually, a process that can take many seconds. The court's attention can be brought to a particular page by inviting everyone to look at their monitors, upon which the document in question appears for all to see. This undoubtedly saves time, although some judges say that they miss the chance to mark up documents that are presented in this way. The second set of technologies, known as EPE, reflects the old cliché that a picture is worth 1,000 words. Rather than relying exclusively on oral advocacy, court lawyers can present evidence in the courtroom using a wide range of nonverbal tools, including charts, graphs, timelines, maps, diagrams, drawings, sketches, models, animations, reconstructions, and simulations. These can be displayed in the courtroom on individual monitors or projected onto very large displays. A package as common as Microsoft PowerPoint can be used, although for moving images and video, and for three-dimensional work or even holographs, more advanced systems will be deployed. Whatever the techniques, the effects can be striking and memorable. I am still haunted by a simulation that I saw in the early 1990s. This recreated the view in the cockpit of a plane that was crashing, linking the horrendous downward plunge with the recording, as retrieved from the black box, of the voices of the pilots in the final seconds of their lives. Much less dramatically, the extent of a delayed project can be demonstrated powerfully by an animation that compares actual with projected time taken, or complex movements of funds can be captured in a simple graphic rather than by convoluted verbal summary. In all, this tangible or demonstrative evidence has been more widely adopted in the US and other jurisdictions, where civil juries are more commonplace than in England, where interest in this kind of technology has been confined mainly to criminal cases. Even in criminal cases, however, it is interesting to note that many senior advocates and judges in England harbour reservations about the lack of relevant court procedures to control this use of it, and are alive to the possibility of technology being misused in misleading jurors and judges. At a Society for Computers and Law Litigation Support conference in this hesitation was captured by the then Law Lord Lord Griffiths, in paraphrasing one of Disraeli's aphorisms, by suggesting that there are lies, damn lies and graphics. Yet another technology that has shown potential over the years, but has not yet been introduced with fervour across the justice system, is participation in court proceedings via video conferencing. Again, the uptake has been greater in criminal work, for bail and remand hearings conducted through links between prisons and courts, and to enable child witnesses, vulnerable and intimidated witnesses, or witnesses outside the UK to give evidence remotely. The incidence of adoption of video conferencing in civil cases has been notably lower. Generally, parties have preferred to gather together for civil combat, despite some authoritative calls for its take-up, by Lord Wolfe in his final Access to Justice report, by Sir Geoffrey Bowman in his review of the Civil Division of the Court of Appeal, and in June 2 in the Civil Justice Strategy paper issued by the Lord Chancellor's Department. Not long after, in late July 2, for the first time, video conferencing was used for an application for permission to appeal in a civil case to the Court of Appeal. It was significant that the technology was being used in the upper reaches of the court system. The video hearing, conducted by Lord Justice Nurse, was part of a pilot scheme linking the Royal Courts of Justice, Cardiff Civil Justice Centre and Leeds Combined Court. It was realistically expected then, as now, that this technology would help to render the civil justice system quicker, more accessible and less costly. Crucially, though, its potential goes well beyond civil appeals, and would be especially useful for interlocutory hearings, case management meetings, and all manner of other interactions with the courts. Looking forward, the latest generation of video conferencing systems offers the promise of far more reliable and lifelike virtual attendance in court. These systems, as I discuss in Section 3, use technology sometimes called immersive telepresence, which creates the feeling that users are indeed gathered in the same room as one another. So a party, witness or lawyer could appear in court, or in an arbitration or mediation for that matter, and the gravity of proceedings, as well as the gravitas of the judge, could to a large extent be conveyed and maintained in the new environment. Taken together, CAT, document display, EPE and video conferencing are good illustrations of technologies that have been shown to work well in occasional practice, but have not been embraced extensively in the courts. In contrast, they have been widely taken up in various major public inquiries. The most technologically advanced of these has been the Bloody Sunday inquiry, currently being concluded by Lord Savile. Fittingly, as president of the Society for Computers and Law, and for many years the leading advocate of IT amongst English judges, Lord Savile used a wide range of systems, setting up what I regard as the world's most technologically advanced hearing. Over and above all of the systems discussed in this section, Lord Savile also developed an award-winning 360-degree virtual reality model of Londonderry in one, based on historical plans and photographs. Using touchscreen technology, witnesses and others were able to walk through the streets as they appeared at the time. In this way, the technology proved to be a powerful tool to help the inquiry understand as accurately as possible the events of over 35 years ago. Building to a large extent on the experience gained during Lord Savile's inquiry, it was also a success at the Hutton inquiry, supporting a hearing that was swift and notably accessible to the public. CAT increased the pace of the proceedings, and the full collection of transcripts generated were converted into a searchable database of over 2 pages. All evidence put before the hearings, around 1 pages, was put before the inquiry using document image technology. Lord Hutton and the 8 legal teams had continuous access to these transcripts and images of evidence in a courtroom that was reminiscent of a NASA control room, complete with 44 desktop flat screens and 4 large plasma displays of the sort coveted by home cinema aspirants. The entire setup sat on the network of the Royal Courts of Justice, facilitating links to an adjacent court for the public and a marquee for the media. These locations housed a further 12 plasma screens, which also displayed live broadcast of the actual courtroom proceedings. The public had open access to the transcripts and evidence through the inquiry's website, which enjoyed on average over 1 visitors each day. Video and audio conferencing were also used, enabling certain witnesses to give evidence without appearing in the courtroom itself. This was an option for the bereaved and certain intelligence officers. It is striking that all the technologies used by Lord Hutton and most of those used by Lord Savile were recommended for the civil courts by Lord Wolfe in his Access to Justice inquiry in the mid-1990s. Why then is it still a relatively rare civil case that exploits these systems? The main stumbling block, as I keep saying, has been funding. For public inquiries, it appears much easier to secure the investment needed. It is perhaps relevant that the Hutton inquiry did not produce a detailed business case for IT deployment. Common sense prevailed. Past users of transcription and display technology agreed that these systems reduced the length of hearings by around 1/3. You do not need to be Fermat to calculate that savings in lawyers' fees alone would comfortably meet the entire cost of the technology, and so it should also be in civil cases. In some large commercial cases, this is fully appreciated. Take, for example, the claim against the Bank of England by the liquidators of BCCI. Courtroom 7, the venue for the Hutton inquiry, was once again awash with it. This time, the use of it was introduced and driven largely by the major law firm, Lovells, the lawyers acting for the claimants. The use of the technology was also supported by the judge, Mr. Justice Tomlinson. The case demonstrated how effective it can be in the commercial court, with 22 desktop monitors and 4 large plasma screens displaying either the live transcript of the hearing or showing the documents under consideration, taken from a bundle of some lever arch files. Nonetheless, as I say, this scale of IT usage remains unusual, and its widespread adoption across the court system is not envisaged by the government. What about judges and their use of it in the courtroom? Aside from the technologies I discussed earlier in this section, some judges also take laptops into court largely to take notes. Others dismiss this as a fiddle or a distraction. There is no right answer here. We must be able to accommodate in our courts, and elsewhere in the justice system, groups of users of varying abilities and preferences. It is noteworthy, despite my general lamentations about funding, that any full-time judge in England and Wales will now be issued with a laptop if he or she so chooses. Although there is some judicial consternation over the limited range of applications available on their laptops, it was barely imaginable in the early 1990s that judges would ever be given machines at all. Aside from the use of machines in the courtroom and for case management, see Section 6, judges' use of IT does not differ greatly from that of most practicing lawyers. They have word processors, email, access to online legal information systems, some e-learning and training tools, and an intranet for shared judicial materials such as bench books. The last facility is now delivered through what is known as the Judicial Portal, whose birth was a fraught delivery indeed. This portal also replaces Felix, the now legendary conferencing and bulletin board system that has served as an exemplary online community for many years, see Section 4. Where English judges are poorly supported today, in my view, is on the document management front. I speak here not of electronic files for the courts, but of standard tools to help judges name, index, file, archive, retrieve, and share the documents that they create. Judges are not trained to organize their documents on their machines. This is a critical gap, and I believe judges are exposed here to unnecessary risk. For example, they should not on a daily basis be taking the chance that they might lose documents, for example by overwriting, or send out old drafts in error due to lack of sound version control. An industry-standard document management system is needed. More generally, though, to what extent are some of the broader challenges of this book applicable to judges? Can their work be decomposed and multi-sourced in accordance with the thinking of Section 2? Will judicial work be unsettled by the disruptive technologies introduced in Chapter 4? As to the first question, I can see no reason why judicial work cannot be analysed, divided into separable tasks, and, where appropriate, alternative means of discharging these tasks be found. I can see no reason, in other words, why the routine and repetitive work of judges cannot be sourced in different ways. I regularly hear judges say that they are bogged down by administrative matters that others could handle on their behalf. Closer to the heart of their work, there is considerable scope for standardization of parts of the documents they create, directions, orders, and so forth. They could clearly benefit from the use of document assembly technology, see Section 4, if much of what appears in final documents is standard wording with minor variations. Even preliminary legal research could be conducted differently, as is demonstrated by the use of judicial assistants in the Court of Appeal and the House of Lords. Clearly, they could not be employed across the court system, but other ways of sharing know-how and experience could be introduced. At the very least, I submit that the idea of decomposing and multi-sourcing judicial work deserves further study. In relation to my second question about the impact of disruptive technologies, I generally regard their impact on judges much in the same way as I see their effect on clients. They are more likely to support rather than eliminate the traditional ways of working. In summary, following the classification of Chapter 4, I expect that for judges, document assembly, relentless connectivity, e-learning, closed legal communities for judges, and workflow and project management will bring greater efficiencies, while the electronic legal marketplace, online legal service, legal open sourcing, and embedded legal knowledge will have little direct impact. One category of system that might challenge the judicial role, however, is my 10th disruptive legal technology, online dispute resolution, ODR. I explore this subject in the next section. Before moving on to ODR, I must return, by way of conclusion to my trip across the uneven terrain of courtroom and judicial technology, to the question of funding. Around £1 billion is spent in the UK each year on government computing. Given that the judiciary is one of the three branches of government, is 1/3 of that gargantuan sum allocated to the courts and judges? Not even nearly. According to my calculations, they receive more like 1/30 of the pot, and the result is administrative and management systems that are often unacceptably dated and inefficient. While the court system has no doubt had its share of problem projects, the major stumbling block to progress has been HM Treasury's unwillingness to pay directly for the technology that is needed to impel the civil courts into the modern world. This cannot be funded by court fees. To put in place court systems that would befit the English legal system will require a decade of substantial investment. 6. Online dispute resolution. In Chapter 4, I claim that I have identified 10 disruptive legal technologies that together will fundamentally change the face of legal service. I introduce 9 of these technologies in that chapter, but I defer discussion of the 10th online dispute resolution, ODR, until this section, where it fits more comfortably in the flow of the arguments of the chapter. I first gave serious thought to ODR in the mid-1980s, when I theorized as a doctoral student about the possibility of computers replacing judges. I concluded then that it was neither possible nor desirable for computers fully to assume the judicial function. My position has not changed. Judicial decision-making in hard cases, when judges handle complex issues of principle, policy, and morality, is well beyond the power of current and foreseeable computing. I expand upon this in describing my doctoral work in Section 1. I return to a closely related topic, but in a more practical vein, in 1, while working as a member of the Civil Justice IT Strategy Development Group on the consultation paper Civil Justice C Section 6. At that time, I posed a question to my fellow members: is court a service or a place? I thought our team should be giving sustained consideration to whether parties and their advisors needed to congregate together in one physical spot in order to present arguments to a judge. At that stage, I was thinking particularly of video conferencing. With Lord Savile, I had recently visited British Telecom's research laboratories at Martlesham and had been impressed by their 10-year predictions and demonstrators of video conferencing, which turned out to be remarkably accurate and similar to the latest generation of systems, see Section 3. With the prospect of such technology coming into play, I wanted to challenge some conventional assumptions about courts. Specifically, I wondered about the extent to which courtrooms would actually be needed in the future for judicial work. Reflecting and building on these early forays, I now distinguish between 2 different ways in which it and the internet can impact on the resolution of disputes. The first is where elements of conventional dispute resolution processes are replaced by technology. Examples of this include the use of telephone conferencing rather than physical meetings to conduct case management meetings or pretrial reviews with a judge, or where witnesses or parties appear before a judge via video conferencing, or where judges use a sentencing system to help them to work out what prison term a convicted criminal should serve. I do not consider these to be ODR. Rather, these are illustrations of the use of it to substitute or support an inconvenient or inefficient part of traditional proceedings. In the language of Section 2, these are illustrations of using it to source decomposed tasks of the judicial process. This is different from a second set of circumstances when the dispute resolution process, and especially the formulation of the solution itself, is wholly or in large part conducted by or through internet-based systems. This is ODR. A decision that emanates from or is enabled by an online system without human intervention is certainly ODR, as, in my view, is an alternative dispute resolution process that is conducted across the internet without the participants meeting in person. In terms of the evolutionary path that I lay out in Section 2, ODR sits towards the right hand of the spectrum. I accept that the above distinction between IT-enabled convention dispute resolution and ODR may not be a watertight dichotomy. Others cut the ODR cake in quite different ways. Ethan Katch and Janet Rifkin, for instance, in the first book on ODR, developed the interesting argument that, in ODR, technology becomes the fourth party at the table, working in support of the third-party mediator or arbitrator. I like their work, but for current purposes, I prefer to stick to my simpler model. To repeat in shorthand, when the process of resolving a dispute, especially the formulation of the solution, is entirely or largely conducted by or through the internet, then we have ODR. With this broad definition to hand, the best way to understand ODR I have found is through examples. A starting point is the application of ODR to disputes that have arisen amongst internet users. Predictably, the use and growth of the internet has itself spawned legal disagreements, and indeed it is here that we find some of the most widely used and best-known ODR systems. One class of cybersquabble arises amongst disgruntled online traders. In this context, an ODR solution that is often cited is SquareTrade. This service was founded in and has helped to settle hundreds of thousands of conflicts over transactions between traders on eBay, the online auction site. SquareTrade is eBay's preferred dispute resolution provider and offers two services. The first is a free negotiation process, a web-based forum that enables users to try to sort out their differences on their own. Many disputes are said to be resolved at this stage. However, if agreement is not reached, SquareTrade also provides an online mediation process with a human mediator. This costs us $1. eBay subsidizes the balance of the expense. The mediator seeks to understand both points of view and to encourage reasonable settlement. If a resolution cannot be reached, the mediator recommends a solution based on principles of fairness and good conduct. It is said that this process generally takes 10 days. Another type of internet-related altercation is the domain name dispute. It is not unusual for dubious attempts to be made to use or sell an internet address, which carries a brand that arguably belongs to another. Since the management of the domain name system has been the province of the Internet Corporation for Assigned Names and Numbers, ICANN. Consistent with ICANN's policy for the settlement of such disputes, various ODR systems have been developed, each designed to be quicker and cheaper than conventional mechanisms for settlement. On one model, submissions have been made to neutrals selected from a strong panel, experts mainly on intellectual property and internet matters, and this process has been conducted entirely electronically rather than on a face-to-face basis. Beyond disputes that arise from online matters, ODR has enjoyed much wider usage. Perhaps the greatest success story of all is the US company Cybersettle. Launched as a web-based system in one, it is claimed that Cybersettle has handled over 2 claims and settled more than $1 billion worth. Most of the cases have been insurance or personal injury claims. How does it work? Using a patented process referred to as double-blind bidding, a claimant and defendant each submit the highest and lowest settlement figures that are acceptable to them. These figures are not actually disclosed to the other side. If the two ranges overlap, a settlement is achieved, the final figure usually being a split down the middle. If there is no overlap, the process can be repeated. The system is used mainly by claims professionals, lawyers, and insurance companies. Consider this case study. The city of New York, under budget pressures, was looking for a way to cope with a backlog of 4 personal injury claims and to speed their settlement process. Cybersettle was introduced. More than 1 claims were submitted. It is claimed that there was a % settlement rate within 30 days of submission, savings in litigation costs to the tune of $1 million, and an average reduction in settlement time of %. It is hard not to take this approach seriously. Another kind of ODR that merits attention is mediation across the web. When a face-to-face mediation is too costly relative to the amount in dispute or logistically not possible because of the locations of the parties, then an online mediation can be undertaken. Through a blend of web-based tools and human mediators using email exchanges and online discussion areas, conflicts can be resolved or dissolved electronically. Parties to a dispute can therefore settle their differences across the internet without convening in a meeting room or discussing their cases orally. In 2, alternative dispute resolution specialists, the ADR Group, were the first to launch such a service in Europe. Imaginatively, they also offer an e-learning-based training course in online mediation to accredited mediators. Looking beyond commercial and personal injury disputes, ODR has even crept into family law. A system to help divorcing couples to resolve some of their differences has been under development at Victoria University in Melbourne. The objective of the family winner system is the more rational settlement of the disagreements afflicting the % of Australian marriages that end in divorce. Described in an important article in the Harvard Negotiation Law Review, this ODR system is also said to deploy game theory techniques originally formulated by Nobel laureate John Nash and popularized in the film, A Beautiful Mind. Through a series of trade-offs and compensation strategies, the system distributes items in a dispute to those who most desire them. It is claimed that disputants can often achieve to % of what they require, rather than the traditional 55 approach to dispute resolution. The system encourages disputants to focus upon their interests rather than using the negotiation process counterproductively to vent their emotions. If ODR can work in a domain as fraught as divorce law, then applying these techniques in other parts of the legal system should be as easy as walking out of a law library. If it is surprising that ODR is thought to be workable in handling divorces, it may be even more shocking, given that I am rather downbeat in much of this chapter about the government's investment in IT for the English courts, that one of the most successful operational ODR systems was developed and is made available by the court service in England and Wales. This is Money Claim Online, an award-winning system that was launched in 2002. It enables users with no prior legal knowledge to recover money owed to them without handling complex forms or setting foot in a county court. The service covers claims such as unpaid debts and rent arrears up to the value of £1 and enables a claimant to request a claim online, monitor the status of the claim and, where appropriate, request entry of judgment and enforcement. Payment of the court fee can be either by credit or debit card. Defendants can also use the online system to reply to and check the status of their cases. My understanding is that Money Claim Online handles more than 6 claims each year and so is busier than any single county court in the country. This is a remarkable achievement, and the court service is to be commended for its innovation. Along similar lines, although it has suffered from some teething problems, has been the more ambitious system known as Possession Claims Online. This is another ODR application delivered by the court service, and again it is for use by both claimants and defendants. It offers a straightforward way of making claims for possession of residential property for non-payment of rent or mortgage. Status tracking and payment is handled in a similar way to Money Claims Online. Additionally, court diaries for claims issued within Possessions Claims Online can be viewed online. These two systems exhibit electronic public service as it surely should be, reaching out to large numbers of citizens. Around 2/3 of UK homes now have internet access, and providing a modern and streamlined alternative to an often cumbersome paper-based service. More, these systems should also help those who might previously have been deterred by the forbidding nature of the process from pursuing their entitlements at all. I am enthused. Yet I also recognize that I may still be applying yesterday's thinking to tomorrow's world. In the US, the iCourthouse initiative may point to a very different, allegedly more democratic model. The iCourthouse is an online hearing room to which internet users can present their cases. In turn, they are heard and decided upon by lay, volunteer jurors. The court is always in session, and many of the procedures echo traditional court practice. This setup is remarkably similar to various proposals put to me when I made some draft parts of chapter of this book available for discussion on Times Online. The basic idea presented to me was to recruit millions of volunteers who are willing to play the role of juror-cum-judge in relation to disputes put before them. If a disagreement arises, each party would submit written pleadings via some internet-based system to a panel of, say, 1 laypeople drawn randomly from the pool of volunteers. The Solomonic wisdom of Crowds 5 would no doubt then click in, delivering a common-sense judgment, untrammeled by legal niceties. In a sense, this would be a type of mass collaboration or open sourcing in relation to dispute resolution. Who knows if this might work, but it certainly challenges some fundamental assumptions. ODR is potentially disruptive for lawyers and for judges, arbitrators, and mediators. If clients are going online and sorting out some of their difficulties on their own, this is time and money not spent on lawyers. And if differences are being settled without the direct involvement of independent human decision-makers, this might severely impinge on those who make a living from sitting in the middle of warring parties and resolving their disputes. Alternatively, if judges, arbitrators, and mediators end up exercising their responsibilities from their dining rooms at home, this is a disconcertingly far cry from the traditional litigation, or ADR, that most are trained to oversee. Predictably, as ODR gathers force, so too will its opponents. The law is not short of conservatives and reactionaries who will raise countless plausible objections. I welcome debate, and I want ODR to be put under the microscope. At the same time, we should not look uncritically at our age-old traditions. Let me illustrate my point with one example. Skeptics of ODR have often pointed out to me the importance of taking oral evidence from witnesses in physical hearings, a process that cannot be simulated, they say, through ODR. Indeed, without this process, it is claimed that the basic facts of cases cannot be determined or assessed reliably. To this, I say that we should also be open to possible faults in today's methods. The critics seem to regard witnesses as though these individuals have superhuman recall. To get a sense of just how imperfect a human being's perceptions can be, however, we need look no further than a celebrated experiment by psychiatrists. Participants are asked to look at a video recording of basketball players passing a ball to one another. They are also asked to count the number of passes. Unbelievable though this may sound, most viewers fail to notice that a man in a gorilla suit carrying an umbrella is walking in their midst. Witnesses can easily be distracted and are far from infallible when in the courtroom. More generally, we cannot assume that current legal processes cannot be improved upon. Nonetheless, I concede that it is still early days for ODR, and today there is as much if not more cynicism about its potential as there was in the early 1990s about its distant cousin, ADR. What then does the future have in store? Of 2 developments I am quite confident, and of a third I have high hopes. I am confident that ODR-like techniques will in due course be embraced as a way of settling high volumes of fairly low-value disputes. In part, this will displace conventional court work, but it will also liberate a latent market. People and organizations who have not felt able to take action in the past will have an unfussy and yet quasi-authoritative way of sorting out their conflicts. The great social benefit of ODR, in other words, will be in offering access to the inexpensive and simple resolution of disputes that parties would otherwise not feel able to take to the courts. I am also confident that the next generation will often prefer ODR to conventional mechanisms of resolving disputes. Following the thinking of Section 3, clicks will often be preferable to mortals. I have high hopes for ODR in relation to the resolution of commercial disputes, although I cannot yet see how this might play out. Perhaps an entrepreneur or a private equity house or an organizational psychologist will bring this idea to fruition. But I suppose the market first has to recognize that wildly excessive and disproportionate amounts of time, energy, and cash are dispensed on dispute resolution, and this will have to coincide with a dawning realization, and this is my game theory point again, that litigation in the long run may not be in the commercial interests of any party other than in exceptional circumstances. 6. Dispute avoidance. In Section 5, I tell the tale of the power drill manufacturer that claims it sells holes in walls rather than drills. And I ask, what is the hole in the wall in the context of legal services? What is it that clients of law firms really want? What value do lawyers bring to the markets they serve? I say that I know of only 2 satisfactory responses to these questions. In Section 5, I focus on one of these, on the many ways in which clients, when instructing lawyers, are actually wanting the application of lawyers' knowledge in their specific circumstances. The second answer I delay until this part of the book. Based on countless discussions, interviews, and research projects with clients of law firms, this second answer runs as follows. What clients actually want is lawyers who can help them to avoid legal problems, difficulties, and disputes. Clients prefer to have a fence at the top of a cliff rather than an ambulance at the bottom. The avoidance of legal problems has been a running theme of my work since I wrote an article on the subject in the Financial Times in 1. I argued then for the development of a discipline known as legal risk management. The column generated considerable interest, not least from a government department that called upon my services and those of colleagues at Masons, now Pinsent Masons, for several years. The piece also seemed to resonate with many in-house lawyers who complained that their work was dominated by firefighting rather than the strategic management of legal risk. Since that time, lawyers and their clients have continued to talk with some enthusiasm, if a little vaguely, about this idea of legal risk management. However, although conferences and seminars on this subject have proliferated, no distinct discipline has yet to crystallize. I have in mind here an approach which enables the job of lawyers to be genuinely proactive. Although many firms say they already are proactive, clients tell me that most are not. Nor can they be, I argued in and continue to do so today, until they overhaul their working practices. Proactive legal risk management requires more than bright lawyers shooting from the hip when clients suspect they face a difficulty. It requires the development and use of structured and formal techniques and processes that are already used by strategy consultants, professional risk managers, and tax specialists too. Lawyers indeed have much to learn from the world of tax. I have seen, while advising the tax practice of Deloitte, their evolution of a selection of tools for helping clients to identify, evaluate, and control tax risk. In stark contrast, very few legal risk tools have been crafted for the legal profession. When I wrote in 1, I had fully expected the rapid emergence of a wide range of tools for legal risk review. I thought these would include audits, risk reviews, and health checks to help clients to assess, for example, their exposure to various categories of liability, their processes for managing their regulatory compliance, their preparedness for litigation, now including e-disclosure, the threats to the reputations of their organizations, the soundness of their standard form documentation, and the adequacy of their escalation procedures when serious problems arise. I wondered if economists might be engaged to help with some models for quantifying some of the legal risks. I had also expected a corresponding set of services devoted to legal risk control so that the legal risks, once identified, could be kept at bay. Under this heading, I had anticipated some nifty techniques ranging from new-look insurance products to novel forms of standard form documentation, from standardized working practices and procedures to legal risk awareness-raising programs, from embedding legal content into the standard project and business life cycles of client organizations to proposals for entirely novel ways of structuring and prioritizing the work of in-house legal departments. In the event, but a handful of law firms around the world have actually invested seriously on behalf of their clients in legal risk management. The lack of investment and imagination by law firms in this area astounds me. In all the studies that I undertake on behalf of law firms, when I am asked to interview and later summarize the views of general counsel, I invariably hear from these top in-house lawyers that legal risk management is the main focus of their job. General counsel are highly concerned, for instance, about compliance risks. The global regulatory environment is regarded as increasingly complicated and subject to ever more aggressive attitudes by regulators to enforcement. Major international financial institutions have to submit thousands of reports each year to dozens of different regulators and will only be able to carry on doing so efficiently if they are supported by advanced systems and processes. And yet, these tools, legal risk management tools, do not exist. There is an unparalleled opportunity here for innovative law firms to extend their range of services beyond traditional reactive work to a fundamentally different, proactive suite of services. These services will not be a variant of one-to-one consultative advisory service delivered on an hourly billing basis. Instead, they will be a blend of facilities, methods, systems, and services which together will focus on helping clients to identify the legal risks they face, evaluate the severity of these risks, and, where necessary, take appropriate precautionary measures. In controlling legal risk, we will need to move away from the idea that the best and only technique for managing legal risk is to throw lawyers at the job. Another method is to increase awareness of legal risk across an organization so that non-lawyers are able to avoid legal pitfalls without the direct intervention of legal advisors. Pursuing this course, an entrepreneurial US company, LRN, has pioneered the use of e-learning to enable entire workforces to recognize compliance and liability risks for themselves. In a similar vein, the UK legal publisher company, PLC, offers a legal risk service to assist in-house legal departments in educating business people about legal risk. The service includes a portal to a range of legal risk resources, hosted and maintained by PLC, but tailored for subscribing companies. It also includes a series of legal risk modules on thorny legal issues, containing e-learning courses and practical briefings for those not of legal background. It is noteworthy that both of these offerings have been developed not by law firms, but by entrepreneurial and nimble new wave legal publishers. Another way of increasing legal awareness is to embed legal knowledge into organizations in the ways I envisage in Section 4, using tools such as document assembly, workflow, and personalized alerting. There is no shortage of techniques. The difficulty for law firms in all of this is that it is notoriously tricky to encourage clients to pay for the development of legal risk management tools. With fees for conventional legal work already gargantuan and under scrutiny from on high, it is hard to make a business case for spending money on legal problems that have not yet arisen. This dilemma of the aspiring legal risk manager is neatly reflected in the tale of the chief fire officer. In this anecdote, we hear of a large manufacturing company that is suffering from regular fires in its various factories. The chief executive calls for action and demands the recruitment of an individual to sort out the problem. A chief fire officer is duly brought on board, and with the assistance of a team that he builds, the fire problem is brought comfortably under control. In due course, the chief executive leaves the company, and his successor, on arrival, makes it one of his priorities to trim excess costs. On examining the company's figures, his eyes alight upon the not insignificant expense of the chief fire officer and his team. He expresses surprise at the scale of this cost and asks his finance director when the company last suffered from a factory fire. He is told that there have been no fires for over a year. His immediate response is to fire the chief fire officer and scrap his department. Whether in law or in relation to fires, it is hard to quantify the benefits of disasters averted, and so, irrational though it may appear, it is much harder to sell legal risk management services than litigation services. When a dispute arises, the budgets often seem to be without limit. A tiny fraction of that budget is rarely released to avoid litigation in the first place. I can imagine that this is an area where external investors might work with law firms. Whereas lawyers might be unwilling to sink their own profits speculatively into new tools and techniques, private equity houses or major legal publishers may regard legal risk management as a wonderful investment opportunity. More generally, though law firms' lack of enthusiasm for legal risk management services may reflect the deeper structural defect in the relationship between firms and clients that I identify in Section 5, I refer there to the asymmetry of commercial interests between lawyers and those they advise. Most law firms, if we are honest, would prefer to advise on a mammoth dispute than have helped to avoid it. I return to the all-important case study of Cisco. Only when that company's external law firm took on their commercial litigation on a fixed price basis did the lawyer and client come to share the same point of view. Both then had a very strong interest in reducing Cisco's legal risks. In the long run, perhaps law firms will only take legal dispute avoidance seriously when they are sharing legal risks with their clients.